The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampala, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
In Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
The next one is with respect to estate, alright? Gifts, alright? Bequest devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. Now, incidentally, I just got reminded that, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it shall be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the argument.
So, importante, again, sequential, you may skip, but make sure no, that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. Make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations, no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my booklet because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, kung sa law school, nagagawa yun dati, puro arrows, you try to direct your professor on where to use.
Party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
This is before the amendment. And for every allegation, it should be supported by evidence because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of Google under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial agreements.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC. We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Good day to our dear attendees from different parts of the country. I pray that you're all in a great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our virtual law companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer has more than 16 years in the practice of law in the field of litigation, and almost the same number of years in managing his own law office. Currently, he is teaching at the San Sebastian College Recoletos College of Law and College of Criminal Justice of the Cavite State University main campus. He has authored books entitled Conceptual Approach to Torts and Damages and Conceptual Approach to Special Proceedings, both published by the Central Book Supply Incorporated. He is a trained commercial arbitrator of the Philippine Dispute Resolution Center Incorporated. Presently, he works as legal counsel of Del Monte Land Transport Bus Company Incorporated or DLTB. Before that, he has already worked in several companies either as retained counsel or corporate secretary since 2004, applying knowledge in civil, criminal, labor, and corporate laws in the rendering of legal opinions, providing legal consultations, drafting and reviewing of contracts, and representing the companies before judicial and administrative bodies. Let us all welcome Professor Wilson A. Legaspi.
Good day, everyone. I am Professor Wilson Legaspi, and welcome to this free online lecture brought to you by the Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like, follow, and subscribe to VLC Facebook page and VLC YouTube channel. Please also share this live stream with your friends, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. Okay, we will be discussing some of the salient rules in special proceedings. Okay, special proceedings, as we know, is one of the actions that can be filed in a regular court of justice. Okay. Special proceedings is defined as a remedy by which a party seeks to establish a status, a right, or a particular fact. Okay. Generally, special proceedings is considered as an action in rem. Therefore, if it is an action in rem, publication is required not to acquire jurisdiction over the person, but to comply with due process requirements. Special proceedings may or may have no adverse party, especially in proceedings that are considered summary in nature. It does not require the appearance of an adverse party. Okay. Also, no formal pleadings are required unless expressly provided in the rules. Okay. There are many kinds of special proceedings under the rules of court. No, some of them are the settlement of estate of deceased persons, guardianship and custody of minor persons, habeas corpus under Rule 102. Okay, yung adoption and rescission of adoption, previously it is covered by the rules of court, but now it has a separate rule for that. Judicial recognition of filiation, change of name under Rule 103, cancellation or correction of entries under Rule 108, and even recognition of foreign judgment of divorce, although not found in the rules of court, but is still considered as a special proceeding. Similarly, with the declaration of nullity or annulment of marriage, which is covered also by a separate rule. Okay. Puntahan natin unang-una yung settlement of estate. Settlement of estate has three kinds under the rules. It may be a judicial settlement of estate. It may be an extrajudicial settlement of estate, or it may be a summary settlement of estate. Puntahan natin isa-isa. Okay. Judicial settlement of estate. So, this kind of petition shall be filed in court. When we file a petition for the judicial settlement of estate, we must be minded by the rules on venue and jurisdiction. Okay. Venue in the settlement of estate is this. When a decedent is residing in the Philippines, it shall be filed in the place where the decedent last resided before his or her death. Okay. If he or she is not a resident of the Philippines, the venue is in the place where any of his or her properties is situated. Okay. How can we prove the venue of how can we prove the residence of the decedent before he or she died? We can prove the same according to jurisprudence through a certificate of death. Although the certificate of death is not a conclusive evidence, despite the presence of the certificate of death, according to jurisprudence, it can be proven by any other evidence. Okay. Like in any other, like in the rules on ordinary civil action, the rules and venue in the judicial settlement of estate can be waived. So if there is no opposition filed to contest the proper venue, that is deemed waived. Okay. With regard to jurisdiction, we must be mindful of the provisions of BP 129 under Section 19 of Paragraph 4. The jurisdiction is determined by the gross value of the estate. So if it does not exceed 300,000 pesos or 400,000 pesos within Metro Manila, the venue is with the municipal trial court or the metropolitan trial court. If it exceeds those amounts, 300,000 pesos outside Metro Manila or 400,000 pesos within Metro Manila, the venue is with the regional trial court. Now let's go to the functions of a probate court. Now with regard to the functions of a probate court, it is limited to the settlement of estate. Its function is to determine the due execution and authenticity of the will. It can determine the appointment, the proper appointment of the executor or administrator. But it cannot decide on the issue of ownership. Okay. Because its function is limited to the settlement of estate, it cannot decide on the issue of ownership. That is a function of a regular court. But jurisprudence has determined some exceptions. As stated, some exceptions wherein a probate court can determine the issue of ownership. Okay. In an instance where all the parties are the heirs to the settlement of estate, where all the parties consented, no, they agreed that the probate court can determine the issue of ownership. And when the issue of ownership is just for the purpose of collation, to determine whether or not such particular property must be included in the estate of the decedent. Okay. Just recently, the court has made a landmark jurisprudence in the case of Treyes versus Larlar. That was decided by the court on September 8, 2020. In this case, okay, the court has abandoned its previous ruling that there was a need to file a separate petition for the determination of heirship. Okay. But in this case of Treyes versus Larlar, the court said that it is no longer necessary because according to them, under Article 777 of the Civil Code, the right to succession arises from the moment of death of the decedent. So there is a need to file. There is no more need for an heir to file a petition for the determination of heirship, because that is determined from the moment of the death of the decedent. Its right arises, the heir's right arises from the moment of the decedent's death. Okay, so in an action for reconveyance, for example, okay, uh, if an affirmative defense is made that the heir uh, has yet to determine whether he or she is an heir, is really an heir, no, that affirmative defense must be denied. No. The heir has the capacity to prove that he or she is indeed an heir in that action for reconveyance or recovery of ownership. Okay, that is the essence of the ruling of the court in Treyes versus Larlar. Okay, another kind of settlement of estate is extrajudicial settlement. No? The estate is settled outside of the court proceedings. How it is done and what are the requirements. Okay, the decedent must have left no will and debt. Okay, if the decedent left no will and debt, so the heirs can execute an extrajudicial settlement of estate. How it is done? The heirs must execute a public instrument. If it involves a personal property, they must post a bond. Okay, and such extrajudicial settlement must be published once a week for 3 consecutive weeks before paying the estate tax. Okay, and once the estate tax has been paid, the BIR already issues a certificate authorizing registration. So the title to that property must be registered now to the heirs. Okay. If there is only one heir, instead of executing an extrajudicial settlement, the heir, no, must execute an affidavit of self-adjudication. Okay. Some important points to consider in the settlement of estate, particularly in extrajudicial settlement of estate. Publication, according to jurisprudence, does not serve as a constructive notice to heirs who were not able or who were not aware of the settlement of estate. And because they were not aware, they were unable to participate in such settlement of estate. We cannot reason out that publication serves as a constructive notice, like in other kind of petition, because publication in extrajudicial settlement is after a fact, after the execution of extrajudicial settlement has already been done. No? So it cannot be said that publication serves as a constructive notice to the heirs, no? So that he or she may be barred, no? In claiming his or her part of the residue of the estate. Okay. So registration, once it is published, once the tax has been paid, no, registration must follow. No. The purpose of registration is to bind third persons. Okay. But it does not mean, according to jurisprudence in the case of Republic versus Bacabagdal, decided on January 22, 2020, it does not mean that it cannot be used as evidence by the heir to prove that he or she is indeed an heir. Okay, so the instrument, whether it is an extrajudicial settlement or affidavit of self-adjudication, can be used as evidence to prove that one is an heir. Okay, the third kind of settlement of estate, summary settlement of estate. Requirements: the gross value does not exceed 10,000 pesos. Okay, once it does not exceed 10,000 pesos as its gross value, it should be filed in the municipal trial court or metropolitan trial court. And such petition must be published Okay, before the proceedings may continue. No, ang summary settlement of estate is for academic purposes na lang, no? Kaya dinidiscuss ito. But it is now already impractical due to the amount is way below. Baka sa filing fee pa lang as a publication ay kinain na yung 10,000 pesos. No? So, it now needs an amendment. Okay. So, once a registration of the property has been done after the estate has been extrajudicially settled, okay, and even in the case of judicial settlement of estate, okay, there must be a lien to be annotated at the back of the transfer certificate of title pursuant to Section 4 of Rule 74. Ano ang kahalagahan nito? Okay. The creditors and participating heirs have 2 years to claim the right to the estate already distributed. Okay. Yun ang sinasabi doon. No? Sa annotation at the back of the transfer certificate of title. It is considered as a lien. But it has no application to the heirs who were unaware or prevented from participating in the settlement. Kagaya lang na-discuss na natin kanina, once an heir has been made unaware that an estate has been already settled or they were not able to participate, no, it has no effect on them. Okay, they can always, no, pursue, no, even the other distributors, even the other heirs who were able, no, to get their share in the estate. Their rights must have to be determined. No? And once their rights are determined, according to the case of Ignacio Hernandez versus Lee, decided by the court on September 2, 2020, okay, once their rights are determined, the procedure is not to cancel the partition already made. Magiging tawag dito, magiging ano lang yon, magiging I cannot get the proper term, no. Hindi na dapat na ulitin, no. But the court may order the execution. It will issue a writ of execution to the other heirs in order to get from them the share that must, their corresponding share that must be given to the heirs or heirs who were not able to participate in the settlement proceedings. Okay, pumunta naman tayo ngayon sa probate of will. What is probate? Probate is, it refers to a judicial process where the court determines the due execution and authenticity of the will. Okay, so ito yung function niya. Dinedetermine niya yung whether the will is duly executed, whether the will is authenticated, and to determine the testamentary capacity of the testator. When we say testamentary capacity of the testator must be of sound and disposing mind at the time he or she executed the will. When we say sound and disposing mind, okay, the testator must know the nature of the estate to be disposed of, the proper objects of his or her bounty, and the character of the testamentary act. So what is the basis? What is the reason why the will has to be probated? Because under the civil code, no will shall pass real or personal property, no, without the will being probated. So that's why we have this so-called doctrine of preference of testate proceedings. It states that even though an intestate estate is already being conducted, and during the pendency of the proceedings, a will is discovered, the proceedings of the intestate estate proceedings will have to be suspended in order to give way to the probate of the will. The reason is, as much as possible, we have to respect the wishes of the testator. Okay, the will has two kinds. It may refer to notarial will. It may also refer to holographic will. notarial will has formalities of its own before it can be allowed by the court. Okay, alam na natin yan sa law on succession. No? Marami siyang requisites. No? Like the fact that it must be written in a language or dialect known to the testator. It must be numbered correlatively in letters at the upper at the right hand margin. It must be signed at the left hand margin. The each and every page must be signed at the left hand margin, and the testator must sign the document at the end of the document, no, in the presence of the attesting witnesses. No. And also the witnesses must sign each and every page thereof in the presence of the testator and of one another. No. Those requirements must all be stated in the attestation clause. Mas simple yung holographic will. No? The law simply requires that it must be written, entirely written, dated, and signed by the testator. Okay. Pumunta naman tayo sa concept ng reprobate of will. Okay, reprobate of will. No? It is akin to recognition of foreign judgment. No? Why? Because the will is probated abroad. Okay. If the will is probated abroad, it can be reprobated here in the Philippines. But there are requirements to be present first. There are elements to be present before the court can allow the reprobate of the will here in the Philippines. Unang-una, the will must be executed in a foreign country in accordance with the law of that country. Okay. The testator must have been residing therein when he or she executed the will. Okay. And the will and the petition for probate is filed in the court, which is a probate court. If those elements are present, it can be reprobated here in the Philippines, provided we follow the rules on evidence, our rules on evidence with regard to the recognition of foreign judgment under Section 24 of Rule 132. What does that provision state? So that the certificates of allowance of will, which is probated abroad, together with the law of the country regarding the probate of will, must be pleaded and proved in the Philippines. Okay. Paano? By official publication of the law of that country where the will is probated. Okay. Or if not by official publication, by through a consularization of document, or by a copy attested by an officer having legal custody of the record, together with the certification of our own embassy or legation, or even the Department of Foreign Affairs, that such officer has legal custody of the record. Or yung tinatawag ngayon na through the Apostille Convention, that is already included in our provision on the rules on evidence, no? By through a certificate issued by a country which is a party to a treaty or convention in which the Philippines is also a party. Okay, through the Apostille Convention under Section 24 of Rule 132 as amended by 19-08-15. So paano ba yung Apostille Convention? Itatatak yung word apostille on the face of the document. Okay. If not on the face of the document, it must be through, kung tawagan na yung allonge, it is a slip which will be attached to the said document, either in the certificate of allowance of will, and in a copy of the law of the country concerning the probate of will. Itatatak yon doon sa slip or on the document itself. Okay. So in that way, the will can be reprobated here in the Philippines. Okay. So once the will has been probated, or in case it is allowed in a foreign country, once a will has already been reprobated, the court will now issue the letters testamentary. Ano ba yung letters testamentary? Ito yung yung power na appointment na ini-issue ng court to the person named in the will as the executor. Okay. If there is somebody that is appointed as executor in the will, the court will issue letters testamentary to him or her. But it is not automatic. The executor must first accept the trust. Okay. And he or she must post a bond. So once he or she refuses the trust or did not post a bond, the court will instead issue letters of administration. To whom? Okay. There is an order of priority who may be appointed, who may be issued letters of administration. Okay. The surviving spouse. Second is the next of kin. Third is any person appointed by the by such surviving spouse or the next of kin, chosen by the surviving spouse or the next of kin to be their administrator of the estate, or even the creditors if no appointment has been made within a period of 30 days. So kailan importante yung letters of administration? Kailan ito ini-issue? When, although there is a will, but the testator did not appoint an executor. Okay. Although there is a will and there is an executor, but the executor refuses to accept the trust or did not post a bond. Okay? Kung walang will, so ibig sabihin ng proceedings ay intestate estate. So the court also may issue letters of administration. Okay? What are the duties of executor and administrator? So primarily to manage, to settle the estate. So settle a claim against the estate. It can even file an action against those who has an obligation to the estate. In other words, they can manage, they can settle the estate, diba? And what? Okay. So yun ang kanilang mga pangunahing responsibilities. No? They can even dispose of the property belonging to the estate. But since disposition of the property is an act of ownership, they need the approval of the court. Okay. Sino naman yung tinatawag na special administrator? Special administrator can be appointed if there is a delay in the appointment of executor or administrator. Minsan kasi naging contentious ang issue. Sino ba ang dapat na ma-appoint? Once somebody files a petition for the issuance of letters of administration in his or her favor, or even in favor of somebody else, someone may contest. So nadidelay ang proceedings for the settlement of estate. May mga obligasyon na dapat na bayaran because mayroon ng mga nag-file ng claim. So the court may appoint a special administrator temporarily, kung tawagin niya minsan ay temporary administrator, to preserve the estate once a delay has yet to be solved. Pero kung meron ng ma-appoint na administrator, regular administrator, the court may now revoke the authority of the special administrator. So once the letters of administration or even letters testamentary has already been issued, ito na yung gagawin ng court. No? Issue a notice if there is a claim against the estate. Okay. Issue a notice, have it published. Okay. What are the claims that can be made under Rule 86? The claims to be made under Rule 86 are the following. Funeral expenses, expenses for the last sickness of the deceased, claims arising from contract, kung tawagin ay contractual money claims, or judgment in a case for sum of money filed against the decedent. Those kinds of claims are the claims that can be made against the estate under Rule 86. Kailan ito dapat na i-claim? Within the period provided in the order of the court. Yung notice na inisyu niya. No? Within the period provided in the order of the court, which must not be less than 6 months nor more than 12 months from the date of the first publication of the notice. That must be made within that period. If not made, according to the rules, the claim is forever barred. Okay? The claim is forever barred. So dito ay nagiging totoo yung hindi nagiging totoo yung kasabihan, no, na walang forever, no. Merong forever alin. Hindi ka na pwedeng mag-claim, no, once na lumampas na yung period. But merong exception. Okay, ano yung exception? No? If a claim is in the nature of counterclaim, merong ipinail na action, no, na kaso yung decedent while he or she was still living, and the defendant has made a counterclaim. Eh natalo yung claim ng decedent, no? Ang court ay ang decision ng court ay naging favorable against the defendant who has a counterclaim against the decedent. No, so it is one of the exceptions. It can be made even after the lapse of the period. Another exception, no, yung if there is reasonable ground, no, for the claimant, no, even though he or she wasn't able to make a claim, no, within the original period provided by the court, no, and there is reasonable circumstance for the court to grant the claim of the defendant. It shall be the court shall give the defendant 1 month, no, after within which to file a claim. Okay, how is a claim made? The claimant will file a claim to the executor or administrator with the necessary vouchers as its support or any other kind of evidence of indebtedness on the part of that decedent, which he or she owed, to the claimant. And once there is no contest, once that executor or administrator determines that the claim is valid, so it will settle the claim of that claimant. No? But if contested, so magkakaroon ng court action regarding that. Okay. Meron ding tinatawag tayong contingent claim. It is a kind of claim that can also be made against the estate under Rule 86. When we say contingent claim, no, the claim is subject to the happening of a certain event or condition. Okay. That claim, which is contingent, if that becomes absolute, the claimant will have 2 years within which to file a claim against the estate. There's no problem even if the estate, the residue of the estate has already been distributed. No? The holder of the absolute claim, which was previously a contingent claim, can even make a claim against the distributee of the residue of the estate, provided they follow a condition as provided in Rule 86. Such contingent claim must be made like in any other claim. It must be made within the period provided by the court, which must not be less than 6 months or more than 12 months from the date of the first publication. Okay, so yan ang naka-state doon sa rules. Okay. If it is not followed, it will be barred forever. Ano ba magandang halimbawa ng contingent claim? Yung claim made by a plaintiff against the decedent in an action. the claimant filed a case, for example, a sum of money against the decedent while the latter was still living. And during the pendency of the action, the defendant died. No? That can be considered as a contingent claim. Bakit? It depends, no, on a certain event, whether the court may decide in his or her favor. Okay. It is necessary during the pendency of the action that the plaintiff in that case must make a claim against the estate within the period provided by the court. And if the action filed by the plaintiff uh, uh, is decided in his or her favor, okay, and that decision has become final, it now it will now become an absolute claim that can be made within the period of 2 years. So that is the rule provided in Section 20 of Rule 3 of the 1997 Rules of Civil Procedure in relation to this provision under Rule 86. Okay. It may happen that the obligation of the decedent while he or she was still living is joint or solidary with the other debtors. So the rule is if the decedent already died, the claimant may claim only a portion that the decedent owes to the claimant, no? If it is a joint obligation. If it is a solidary obligation or a joint and several obligation, the claimant may file a claim on the whole of the obligation, no? Because the obligation is solidary. And once the estate has paid the whole of the obligation, the executor or administrator may file an action or even may demand with a claim with the other debtors as regards its share in their share in the obligation. Okay, so joint or solidary obligation of the decedent. But if the obligation is secured by a real estate mortgage, okay, when the obligation is secured, the rules to be followed are this: no? The claimant may waive its claim, her, his or her claim on the mortgage and proceed with this or her claim as like any other creditor. Or it may institute a judicial foreclosure of mortgage under Rule 68 of the Rules of Court. And any deficiency he or she can still make on the estate of the decedent. Or he or she may file a petition for the extrajudicial foreclosure of mortgage. In case of extrajudicial foreclosure of mortgage, whatever deficiency there is, he or she can no longer claim. So that is the rule provided under Rule 86. Okay. Rule 87 naman, claims by and against the executor or administrator. What are the kinds of actions that can be brought under Rule 87? Unang-una, recovery of real or personal property or the enforcement of lien thereon or even an action for damages. Ano ba yung halimbawa ng cases involving recovery of real property? Yung action for reconveyance, action for quieting of title, recovery of personal property, yung action for replevin. Okay? Ano ba yung halimbawa ng action for damages? Quasi-delict. Okay? Those are the kinds of cases that can be brought under Rule 87. The claim is against the executor or administrator. And even the executor or administrator can file a claim on behalf of the estate in these kinds of action. Okay. So pumunta tayo sa rules on property belonging to the estate that has been concealed, embezzled, or misappropriated. If this happens, the following rules are to be observed. No? the executor or administrator can file a petition on court in order to what? To examine, to subpoena a person who is suspected to have concealed, embezzled, or misappropriated the property. Okay. If he or she refuses to be examined, he or she can be cited in contempt or even imprisoned, just to compel him or her to be examined by the court as regards the property suspected to have been concealed, embezzled, or misappropriated. Okay. Paano kung yung mismong deceased ang nag-conceal ng property prior to his or her death? Siguro natatakot siya na habulin ng mga creditors. No? Kung tawagin niya sa revised penal code yata ay fraudulent insolvency. Okay? So what is the rule? If that is the case, the executor or administrator can file a case to recover the property that has been concealed, embezzled, or misappropriated. But the creditor shall shoulder, the creditor or creditors shall shoulder the expenses and the cost of the proceedings. What if the executor or administrator failed to file an action to recover the property that has been concealed, embezzled, or misappropriated by the decedent himself or herself? The creditor can still cause the filing of the action, provided it secures the permission of the court and the creditor or creditors post a bond. Okay. In that way, the executor or administrator is compelled, will be compelled to file an action for the recovery of the property. What if the property that has been concealed is done by the decedent in favor of the executor or administrator? Okay. So the creditors now can file an action even without the participation of the executor or administrator, and even without uh, posting a bond before they can file an action. So that is the rule provided under Rule 4087. Okay, appeals in special proceedings. We all know that in special proceedings, it involves multiple appeals. Why multiple appeals? Halimbawa, the will is probated. The court has already determined its due execution and authenticity, as well as the testamentary capacity of the testator. And thereafter, it issues letters testamentary or letters of administration. The aggrieved party can file a petition on the order of the court allowing the probate of will only on that subject matter. That is why it requires a record on appeal, because the appeal is to be made with regard to that particular subject matter. Hindi kasama yung subsequent proceedings like in the issuance of letters testamentary or letters of administration. It requires a different proceedings. That proceedings will continue so as not to delay the settlement of estate. Okay. So appeals in special proceedings is by notice and record on appeal. How it can be made? Either under Rule 40 or Rule 41. Rule 40 pertains to the decision, to the appeal of the decision of the municipal or metropolitan trial court to the regional trial court. While Rule 41 pertains to the appeal of the decision of the regional trial court to the Court of Appeals. Okay, period in filing a notice and record of appeal is 30 days. Unlike in ordinary appeal, 15 days only. But since it requires a record on appeal, the period of appeal is 30 days, whether under Rule 40 or Rule 41. Okay. Tapos na tayo sa settlement of estate. Now we go to the rule on the declaration of absolute nullity of void marriages and annulment of voidable marriages under AM number 02-11-10-SC. Okay. So who can file the petition for the declaration of nullity of void marriages? Only the husband or wife. No. The general rule is only the husband or wife. Walang pakialam yung ibang tao. Unlike in a petition for annulment of marriages, pwedeng yung relatives of the insane person. Di ba? No. But in the petition for the declaration of nullity of void marriages, only the husband or wife. But merong exception, no, na ibinigay ang jurisprudence. So alam na natin yung decision ng court sa Fujiki versus Marinay. No? Spouse in a subsisting marriage, they can assail the subsequent bigamous marriage. Okay? The spouse in a subsisting marriage, they can file a petition to declare null and void the subsequent bigamous marriage contracted by their spouse with another. So technically, hindi sila party doon sa bigamous marriage. Hindi sila ang husband or wife doon. But they can assail, no, the subsequent bigamous marriage. Anong reason na ibinigay ng jurisprudence? Prior spouse has a personal and material interest in maintaining the integrity of the marriage and the property relations arising from it. Oo nga naman, di ba? Kung sino mang merong personal and material interest, it is no other than the spouse in a subsisting marriage. Pangalawa, it comprises the public record of his or her marriage. Okay. So that is the reason, those are the reasons provided in the case of Fujiki versus Marinay. No? Fairly old case na yan, June 26, 2013. What is the venue? The venue is the following, no? Where it can be filed in the place where the petitioner resides for at least 6 months. Okay. Or in the place where the respondent resides for at least 6 months also. And in case of non-resident respondent, it can be filed anywhere in the Philippines where he or she may be found. Okay, at the option lagi ng petitioner. Sapat na bang i-allege ang residence ng either the petitioner or the respondent for the court to acquire jurisdiction over that petition? Okay. So ngayon ay mas pinahigpit na ng court, no? How can a residence be proved? How can the residence of the petitioner or the respondent be proved? No? According to OCA Circular 63-2019, it can be proven by the following. Kailangan magkakasama to. Not any of the following, but by the following. No? Sworn certification of residency with house location sketch issued by the barangay where the petitioner or respondent is residing. Okay. Kagaya kahapon, may kapapakuha ko lang dyan sa Las Piñas. Sworn statement of counsel of record. No? Pati kami, mga abogado. No? Para sa mga kliyente namin, mag-execute kami ng sworn statement, no? Na talagang nakatira doon yung mga kliyente namin, no? Doon sa lugar na yun, for at least 6 months. And any, but not limited to the following. So sworn certification without sketch, sworn statement of the counsel of record, and any of the following. No? Utility bills, Meralco o Maynilad o kung ano man yan. O kaya yung mga billing sa mobile phone natin o sa kung ano man. Government issued ID or company ID bearing the residence, the address of the petitioner or the respondent. Kung nangungupahan, kailangan ng notarized lease contract and receipt of payment of rentals. Transfer certificate of title. Although sa transfer certificate of title, minsan general na yung pagkakalagay ng address doon. Hindi pa talaga specific yung address. So, kailangan may kasama ring tax declaration or even deed of sale, no? Kung pinoproseso pa lang, no? Yung registration of title and the like. Okay. Mas pinahigpit na, no? To determine jurisdictional compliance with the jurisdictional requirements on venue because of the things that happened in the past. Now let's go to the recognition of foreign judgment on divorce. Okay. Statutory basis. The basis is found in Article 26, second paragraph of the Family Code, where a marriage between a Filipino citizen and a foreigner is validly celebrated and divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under the Philippine law. Okay, merong marriage daw between a Filipino citizen and a foreigner, and the foreigner obtained a divorce abroad. So, ganito ang simple understanding ng Article 26. At makita natin mamaya yung development ng jurisprudence. So, the Philippine spouse shall have the capacity to remarry. Ang simple understanding natin dyan, it is the Philippine spouse who shall file a petition for recognition of divorce obtained by the Filipino, by the foreigner abroad. So, how is recognition made? Unang-una, yung decree of divorce at yung law of the country, no, where the divorce is obtained, must be pleaded and proved in the Philippines. How? By the official publication of the law on divorce and the decree of divorce. Kagaya ng na-discuss na natin kanina, no, sa reprobate of will. Pangalawa, by consularization of document. Paano yung consularization of document? Through a copy attested by the officer having legal custody of the record and by a certification issued by our embassy or legation, no? Or even the Department of Foreign Affairs, that such officer had the right to take custody of those documents. And through apostille convention. So napag-aralan natin kanina, what is apostille convention is, no? Where the Philippines acceded thereto on September of 2018, and the convention took effect in our jurisdiction on May of 2019. So there are three ways, no, of how a decree of divorce and a law on divorce of such country where the divorce is obtained can be recognized in the Philippines. Failure to do the same, the doctrine of processual presumption will apply. That means that the Philippine law, no, shall be made applicable. E paano yan? Wala naman tayong divorce pa rito. So, alam nyo na magiging konsekwensya, no? Once we fail to follow, no, the provision of Section 24 of Rule 132 on the rules on evidence, no, that the recognition of divorce must be denied. Okay. How do we interpret the divorce decree? No. Sinagot siya sa case ng Inre Takahashi, no? December 05, 2019. Okay. This is important because hindi naman lahat ng divorce proceedings ay contested. Kagaya sa Japan, no? Kung hindi na magkasundo ang mag-asawa, marami kasi akong na-encounter na ganyan sa mga kliyente. Pupunta lang sa City Hall. At doon ay mag-execute sila na kung ano, yung family registry, and then okay na. Okay. Previously, ang concern, sige, dito muna tayo tumutok, divorce decree. So how can we interpret the same? Hindi, wala talagang divorce decree dahil wala namang proceedings that are contested. So meron silang divorce report or divorce certificate. Ang sabi ng court sa case ng Inre Takahashi, divorce decree deems to include the divorce report, divorce certificate, or its equivalent when divorce is obtained by other than court proceedings. Okay. Anyway, ang sabi ng court sa Inre Takahashi, these documents are considered written official acts or records of official acts of sovereign authority, which is considered a public document under our rules on evidence. Okay. So, kahit na divorce report lang yan. Divorce certificate lang yan. Baka kahit yung family registry na ini-issue sa Japan, no? It can be recognized already in the Philippines for the divorce to be recognized here in the Philippines. Okay. We must also be mindful of the ruling of the court in Rower versus Rodriguez that divorce degree is recognizable in our jurisdiction. Anyway, with regard to status of marriage, that is considered as in rem. But it is different when we are talking about the custody, care, and support of children, and even the issue of damages, no, that is filed, no, together with the divorce petition for divorce. No. Unang-una, it can be considered as action in personam. So the court, our court here must still determine, no, the merit of the claim. No. Through what? Through the notice given to the other party, to give that other party opportunity to oppose. No? So notice must be given, no, to the other party in order for that party, especially Filipino spouse, to give the opportunity to oppose. Okay, so who should file a petition for recognition of foreign judgment on divorce? Simple understanding or simple reading ng Article 26 ng Family Code. Parang yung Filipino spouse. Pero mamaya malalaman natin with the development of our jurisprudence under Article 26 of the Family Code. Pero unahin muna natin sagutin ang issue na whether or not a former Filipino citizen can file a petition for divorce which can be recognized in the Philippines. Take note, former Filipino citizen. That is answered in the case of Republic versus Orbesido. Sabi ng court, even a former Filipino citizen can file a petition for divorce, and such a petition for divorce can be recognized in the Philippines. Okay, why? The prime consideration is his or her citizenship at the time the divorce is filed, the petition for divorce is filed, and not at the time of his or her marriage. Okay, when he or she is already a foreign citizen at the time he or she filed a petition for divorce, he or she can do so, and that divorce degree obtained can be recognized here in the Philippines. Republic versus Orbesido. Corpus versus Santo Tomas. The issue here is, does the foreigner have the right to file a petition with the court, our court here, for the recognition of foreign divorce decree? Again, simple reading of Article 26. Para bang ang Filipino spouse lang ang pwedeng mag-file ng petition for recognition of foreign judgment on divorce. But in Corpus versus Santo Tomas, ang sabi ng court, pwede. The mere fact that you became a subject of a petition for divorce, a party in the petition for divorce, whether you are a foreigner or not, it will give you capacity or personality to file a petition for the recognition of foreign divorce here in the Philippines. Republic versus Manalo, the issue naman dyan ay, does a Filipino citizen have the capacity to remarry after initiating a divorce proceeding abroad and obtaining a favorable judgment against their alien spouse? So dito, Filipino na ang nag-initiate, no, ng petition for divorce abroad. Okay, again, simple reading of Article 26, para bang hindi po pwede. But in the case of Republic versus Manalo, ang sabi ng court, po pwede. Okay. Ang sabi sa Article 26, it used the term obtained by a foreigner spouse. It does not say initiated by a foreigner spouse. Okay. So, a Filipino citizen can even initiate a petition for divorce abroad. At sabi pa ng court, even if we conclude that the term initiated or obtained is synonymous with initiated, we must comply with the spirit of the law than to the letter of the law. Okay, so that is the essence of the ruling of the court in Republic versus Manalo. So okay, so what is the reason? The reasons is expounded. The reasons are expounded in the case of Racho versus Tanaka, no? June 25, 2018. No? Ito yung decision na ginawa after the decision of the court in Republic versus Manalo. Okay. The prohibition of Filipinos from participating in divorce proceedings will not be protecting our own nationals. Okay. So divorce must be recognized even though it is the Filipino or jointly with his or her foreign spouse who obtained the divorce abroad. So ngayon lang yan, napakarami nang nangyaring petition for divorce and petition for recognition ang nangyari ng mga nakaraan. That's why some practitioners, no, ay nagiging creative sa pagpapay ng petition for recognition of foreign judgment on divorce. Bakit? Lalo sa Japan, talaga namang nakakasundo yung asawa na mag-file ng petition for divorce. Minsan nga ay baka Pilipina pa yung nangungunang mag-file. So, kalimitan ng ginagawa ng mga practitioner dyan ay sinasabi na lang na although tutol ang kalooban ng babae o ng lalaki na mag-file ng divorce, pero gusto ng asawa niya. So, he or she can do nothing. Para lang palabasin na ang nag-initiate ng divorce ay ang foreigner. But now, with this ruling of the court in Republic versus Manalo and Racho versus Tanaka, no, maiiba na. Okay. So what is the proper proceeding that the party should avail of in the filing of a petition for recognition of foreign judgment on divorce? Okay. According to the court in Corpus versus Santo Tomas, no, na-discuss na natin kanina yung case na yan, the recognition of the divorce decree does not by itself authorize the cancellation of the entry in the civil registry. A petition for recognition of foreign judgment is not the proper proceeding contemplated under the rules of court for the cancellation of entries in the civil registry. So yun lang. Na-recognize lang yung petition for recognition of foreign judgment on divorce. Nothing else. Hindi pwedeng magkaroon ng annotation niya sa certificate of marriage. Okay? Ano ang kailangan na i-avail? According to the court, the recognition of foreign divorce decree may be made in a Rule 108 proceeding, correction or cancellation of entry. Okay? So we have to comply, we have to file a separate petition under Rule 108. Pero ang sabi rin ng court, pwede namang pagsamahin na yan. So ang ginagawa naman namin ngayon, petition for recognition of foreign judgment on divorce with cancellation of entries. And since for Rule 108 yan, saan yan ipinapile? Doon sa court where the record is situated, where the marriage is solemnized. Hindi na po pwedeng kahit saan. Tulad ng ginagawa namin prior to the ruling of the court in Corpus versus Santo Tomas. We follow the procedure in declaration of nullity or annulment of marriage, particularly to venue. Noon yun. But with this ruling of the court, we have to comply with the provision of Rule 108. So napag-usapan na natin yung Rule 108. Now let's go to Rule 108 together with Rule 103, change of name, and also Republic Act 1948 as amended. So ano ba yung distinctions ng tatlong procedures na yan? As to the scope, as to grounds, as to who may file, as to venue. Okay, Rule 103, as to scope, it only covers change of surname. Dahil yung change of first name ay nasa RA 1948 na yan. Okay? Hindi lang change of first name ang pupwede sa Republic Act 1948, even yung correction of clerical or typographical errors na dati ay nasa Rule 108, cancellation or correction of entries. Okay, and change in the together with the change in the month or day of the date of birth of the petitioner, no? And change of sex. Okay, yung male or female na nasa certificate of live birth. Okay. Okay, so yon ang distinctions ng as to the scope. As to grounds, under Rule 103, you file a petition for change of surname because it sounds ridiculous, or changes happen because of a legal consequence. Okay, or you have been using that surname since you were a child. Okay, so those are the grounds that can be filed under Rule 103. Same with Republic Act 1948. The name is ridiculous, di ba? Or you have been using that name since you were a child. In fact, yung lahat ng records mo ay yun ang ginagamit mong pangalan except sa certificate of live birth. So you need to make a correction. As to who may file, under Rule 103, only the petitioner, whose surname is whose name is whose surname is to be changed. Unlike in RA 1948 or Rule 108, not only the petitioner himself or herself, even any other person who is interested to have that entry or entries changed. As to venue, change of surname must be filed. Petition for change of surname must be filed in a place where the petitioner is residing for at least 3 years. Unlike in RA 1948 and Rule 108, it can be filed in the place where the record is situated. Okay. Okay. Some issues that must be addressed at under Rules 103 and 108 and Republic Act 1948. So these are the issues. Should a woman whose marriage was previously annulled or declared annulity file a petition in court to allow her to use again her maiden surname? Okay. The court said that you need not file a petition for that. Although you can, but it's no longer necessary. Unang-una, the provision of the civil code states that a woman, a married woman, may use the surname of her husband. Okay, so it is not mandatory for her to use the surname of her husband. No? Much more, she is not required to file a petition to resume her use of her maiden name. Okay. Another issue. Ito kamakailan lang to, nung November 11, 2020 lang to. Does a legitimate child have the right to use the surname of his or her mother as his or her surname? According to the court, in the case of Alanis versus Court of Appeals, pwede. Again, sinight ng court ang civil code that the child shall principally, sabi doon, the child, especially the legitimate child, shall principally use the surname of his or her father. It does not say that the legitimate child, shall exclusively or shall only use the surname of his or her father. So, word principally. So, if the child chooses that he or she use the surname of his or her mother, she can do so. Okay. After all, it is in compliance with the objective, with the rationale or the reason why we have why the Philippines became a signatory to the treaty known as the Convention on the Elimination and Discrimination Against Women. It is also in compliance with the spirit of the law, particularly the Constitution, giving importance to women, and other laws like the uh, law that yung women in nation building. Okay. So that is the essence of the ruling of the court in Alanis versus Court of Appeals. Another issue under rules 103 and 108 and 1948 is sex reassignment a ground for change of first name under Republic Act 1948 and cause for cancellation of entry under Rule 108? Hindi. Unang-una, Republic Act 1948 does not state sex reassignment as one of the grounds, no, for changing, no, the first name of a person. It will not also cause a proper ground for the cancellation of entry under Rule 108 or correction of entry under Rule 108. Anong i-correct? Talaga namang lalaki ka. Diba? So yun ang sinasabi ng court. And of course, it needs, kung talagang gusto nila, it needs a legislation, no, to effect the same. But as long as there is no legislation, no, allowing the correction of entry under Rule 108, no, on the basis of sex reassignment, hanggat walang law, you cannot do the same. Kabaliktaran naman yan, no, doon sa person who has a condition of CAH, yung congenital adrenal hyperplasia. No? And a person under this condition practically has two sexes. No? He or she may be male or female. If that condition exists, no, the court can allow the change of first name or even correction of entry under Rule 108. That is according to the Court of Republic versus Kagandahan. Unang-una ay hindi naman sinadya eh. No? Ito ay a rare condition that sometimes happen to a person. So, sa mga ganong sitwasyon, ibinibigay ng court ang desisyon doon sa affected individual para mamili ng kanyang kasarian. So, Republic versus Kagandahan. Another issue, can the filiation and legitimacy of child be a proper subject of the petition for correction of entries in his or her certificate of live birth under Rule 108? Ang sabi ng court, no. Hindi yan ang tamang proceedings. Okay? Ano ang tamang proceedings? So you file a petition for the recognition of filiation, compulsory recognition of filiation under the grounds stated in the family code. You cannot make a shortcut. You cannot avail of the proceedings under Rule 108 in order to clothe you with legitimacy. You cannot do the same under Rule 108. So that is decided by the court in Miller versus Miller, no? August 28, 2019. Another issue, can a marriage be invalidated by resorting to the filing of petition under Rule 108? Hindi rin. No? It requires a direct proceeding. Under AM number 02-11-10. No? Yung napag-aralan na natin kanina. It requires a direct proceeding. But with one exception. In the case of Republic versus Olaybar, February 10, 2014. The party can do the same if there was no marriage that happened at all. Wala naman talagang nangyaring kasal. Okay? There was no marriage ceremony. No? Personal declaration of two persons that they take each other as husband and wife in the presence of the solemnizing officer, and at least two witnesses of legal age, because during marriage ceremony, the parties give their consent to the marriage, no? Provided the other essential and formal requirements are present. Kung meron nun, hindi pwedeng i-avail ang Rule 108. Pero kung walang nangyari talagang kasal, no? Nagpunta lang sa City Hall na nagkasundo yung dalawang bata na pumirma sa blankong tapos nag-uwian na. Kaya ako nagkukwento yan ay actual experience ko yan. Okay? So you can avail of Rule 108. Hindi ako, yung kliyente ko. Okay. Another issue, does a petitioner have to avail of different proceedings? One under Republic Act 1948 and another under Rule 108 if it involves entries that can be made under the different rules. Halimbawa, gusto mo ipabago yung first name mo sa Republic Act 1948 yan. At meron ka rin gustong ipakorek, no? Sa isa sa mga entries sa Certificate of Live Birth mo. So Rule 108. Do you have to avail of different proceedings? Sinagot yan sa case ng Republic versus Felix, June 30, 2020. Ang sabi ng court, hindi na. You need not to avail of different proceedings. After all, kung gagawin yon, it will violate the provision on the principle in our remedial law, yung prohibition against multiplicity of suits. Okay? So, isang proceeding na lang. Mag-file ka na lang sa court. No? And you state all of your grounds. Whether it be grounds that can be considered under RA 1948, meron ka ring correction of entry under Rule 108, pagsamasamahin mo na. So po pwede yan. After all, a regional trial court is a court of general jurisdiction. So marami pang naging issue dyan sa Republic versus Felix, which is a landmark case, no? With regard to Republic Act 1948 and Rule 108. Ito yung isa. Okay. So that is all. That is my presentation. Okay. Thank you for watching and for staying until the end of my presentation. Please visit the VLC website at www.villasislawcenter.com to know more about the virtual law companion. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Together, we can. Thank you.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
In Spouses Binjola Bruce Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tingnan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
The next one is with respect to estate, all right? Gifts, all right? Bequest devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. Now, incidentally, I just got reminded that, well, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it should be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the argument.
So, importante, again, sequential, you may skip, but make sure no, that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. Make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations, no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my booklet because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, sa law school, nagagawa yun dati, puro arrows, you try to direct your professor on when where to do.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the person.
This is before the amendment. And for every allegation, it should be supported by evidence because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement to do under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
He may be held liable for staffa by misappropriation or conversion. Okay, staffa by misappropriation or conversion. Why can't that not be theft? Why can't that not be carnapping, which is of similar nature of theft? Okay, it is because Mr. A's possession over that car is not only physical or material, it is juridical as well. For the next 7 days from the time he rented the car, okay, he not only has physical possession of that car, he has juridical possession of that car as well. Why did I say that?
The other source of labor principles is the Constitution. Do not enter the gates of USC unless you have mastered the four corners of Section 3, Article 13 of the Constitution of 1987. How important is this provision? Based on this constitutional provision, there were questions given in 1988, 96, 98. 2007, 2008, 2009, 2011, 2012. So if this constitutional provision figured in those barriers, then it means that it is a bar area that requires mastery. The first question in 1998 was this: what are the salient features of the protection?
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court Justices, very specific, a representative from the Integrated Bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Unang pumaparte sa mana, BIR. Kasi mayroon tinatag na estate tax. Okay? Maganda ngayon. Isa na lamang ang rate. 6% na lang ng net estate. Okay? Unlike before, the computation of the estate tax was a little complicated. And long before, meron ng estate tax, meron pang inheritance tax na mas magulong po i-compute. Kaya lang, fortunately, ito panahon ni Presidente Duterte, Legislature passed a law simplifying the computation of estate taxes. A flat rate of 6% of the net estate. Hindi na-graduated.
The employer embarked on a retrenchment program only if it was experiencing actual losses. Not necessarily. In the words of the Supreme Court, if the employer can perceive that sooner or later the economy of the company will go down to the drain, then it should do something. The employer of the company should do something. It should not wait anymore for that time or period that the employer or company incurs actual losses.
If what is involved is what appears to be a discriminatory act on the part of government or agents of the government, the proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are two aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
Even though the one foreclosing is not a bank anymore. Why? Because the non-bank step into the shoes of the bank and acquire the same rights and remedies available to the bank. So it's not important that the one foreclosing is a bank. As long as at the outset, the elements are the mortgagor is a juridical person, the mortgagee is a bank, and the mode of foreclosure resorted to by the mortgagee, whoever he may be, upon foreclosure is extrajudicial. It's the reduced period, not the 1-year redemption period. Okay, is this law constitutional? There's this case, Golden Gateway versus Equitable Bank. The argument of Golden Gateway, this law is unconstitutional because by
are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.